We finally have the settlement in Bart's v. Anthropic going through. That's it. It's over. It's done. After almost 2 years and a fantastic fair use ruling, we finally have the settlement all done and dusted, and with it, we've got the resolution of a lot of the questions we've been having. So, we will be going over this not in any great detail, but we will see how all of that got resolved. But the basic ruling from Judge Martinez L. Gwynn: the court hereby grants the motion for final approval and grants in part the motion for attorney's fees for the reasons set forth below. So basically what we have is a ruling that the settlement is fair and it's going through and it's done and all objections are over with. The settlement also provides a fair and reasonable process for the resolution of any disputes. Should any disputes arise among valid claimants for a given work, the special master will proceed with all reasonable diligence and will endeavor to quickly resolve all disputes based on the law. So if you remember, we had a big dispute between the authors and the publishers, and I agree with the authors that it was kind of bogus that the publishers could just insert themselves into a case that they didn't have anything to do with. The authors started the case, the authors pushed it forward, the authors got the big $1.5 billion settlement, and the publishers just saunter in and say, yeah, we'll take some of that. Well, the judge didn't rule for the publishers, but she didn't rule to kick them out either. You're just gonna figure it out yourselves with the special master on a case-by-case basis. Not what the authors wanted, but we'll go over that in a little more detail. Upon the effective date, the parties shall have fully and irrevocably released and forever discharged one another from any and all released claims as to the works on the works list. The court overrules all objections and putative objections to the settlement. So they're all over with, they're all ancient history. So let's talk about what the works list means, because that goes to another question that we had. A number of objections or comments raise the concern that there may be works that otherwise meet the class criteria but are excluded from the works list. However, the works list serves to avoid any ambiguity in what claims are or are not released by the settlement and ensures certainty and finality. Equally important, claims arising out of the use of works that are not on the works list, even if they otherwise meet or appear to meet the other criteria, are preserved and unaffected by the settlement. So that was a question that authors had. I've got these 3 works on the works list, but I've got 10 others that aren't. Either because they didn't meet the criteria or they weren't registered during the time period or whatever. So what about those? Well, if they have any other works that are not on the list, they can still sue Anthropic over those works. And another question was that if someone had 10 works but had registered them all at once under a single copyright registration, does that count as 1 work or 10? Well, it counts as 10 because it's about the works in the works list. So that resolves all of that. Which means, as we figured, Anthropic can still expect a lot of lawsuits going on. Alright, so now let's talk about this issue with publishers. And if you remember, we covered the objection from Professor Leah Victoria Bishop, and there was another as well. They argue that the dispute resolution process is inadequate for failing to include authors' agents, and that the appointment of Mr. Chang as special master will favor publishers. The court carefully reviewed Special Master Chang's credentials and his certification of no conflicts prior to this appointment. The objections to his appointment are thus overruled. So we're letting it go through because Chang's a nice guy and he'll be impartial, but a lot of the experts were saying that even if you had a completely impartial Special Master, the process itself will still tend to favor publishers. So all this is about the contracts that they have with the publishers. And from what I was able to sleuth around and look at, if you're talking about trade and university press books, that default allocation is 50-50. And if you remember when the guy from, I think it was with the American Association of Publishers, when publishers were saying, hey, we need 12% of this settlement, and Bishop complained, the guy came back with, well, be grateful we don't take half, because that's the allocation, 50-50 author and publisher. But that's not a done deal. If there's a dispute, they can take it to the special master, and then the special master will hear the dispute and determine what the allocation should be. And for educational works such as textbooks, there's no automatic default. Their contracts vary all over the place. Probably the special master is going to give deference to the contracts. But it's still, like we said, yanking a lot of that money from the authors because the publishers are presumed to share in the recovery. And then there are the unclaimed author funds that are probably going to be swallowed up by the publishers. So no, there's no final rule here that just gives publishers 10% off the top, but they still get some of the settlement money. So consider, if you're an author, what's that going to mean for you? If you've got to take a dispute to the special master, that's going to be time consuming and it's going to be an expense. The publisher, by nature, is in a much better position to absorb that time and costs than you are. So that means a lot of authors are probably just going to knuckle under, just because they can't afford to deal with it or don't have the time or whatever. And of course, the large publishers have teams of lawyers. Most authors, if you're an author, do you have a lawyer? Do you have one on retainer? Are you going to get one just for this purpose, or are you going to try to do it pro se? The publishers have these big legal departments that know their contracts, know their rights, and they can present very sophisticated arguments about how much they deserve. And it's just going to be a huge asymmetry because you've got an author who signed a contract 20 years ago. They don't have a lawyer. It's been so long they don't remember what their rights were. They may not have understood that to begin with. And even if you say, well, we're not just going to go with the default, it's still an anchor. And challenging them takes effort, especially when, in the opinion of so many authors, the publisher should get nothing. I doubt any of the cases are going to go that way. So even if we assume that Cheng is completely unbiased and impartial, and I've got no reason to assume that he's otherwise, it's still going to be the fact that the process is hugely weighted to the side of the publishers. That's how it is in copyrights. You think you own the copyrights just because you created something? Let this very case be a lesson to you. Copyright is not about you. Copyright is about the big content cartels, the big publishing houses, or the big recording labels, or the Motion Picture Association and all the studios. They don't care about you. So even with a completely neutral special master, this will very much favor publishers. Alright, the action and all released claims asserted against the parties are settled and dismissed with prejudice. It's over, done. I don't even want to hear from you. Plaintiffs, now this next part is about the attorney's fees. That's something we've been talking about a lot too. Because, as is always the case, it's the attorneys that make out from class action lawsuits. Fortunately, she didn't give them everything they wanted, but it's still a nice windfall for them. Plaintiffs moved for 12.5%, $187,500,000 of the $1.5 billion settlement fund in attorney's fees. That's reduced from what they wanted originally, which was $300 million. And they want a reimbursement of almost $3 million in litigation expenses, a cost reserve of $18.2 million for future expenses, including payment to the settlement administrator, and service awards of $50,000 to each class representative. Man, doesn't that make you wish you were a lawyer. Each one gets $50,000 plus their share of the rest. Okay, but in reality, because applying percentage of recovery would result in a windfall for class counsel in light of the hours spent on this case and the size of the fund, the court elects to apply the lodestar method to determine the appropriate amount of fees. You calculate the lodestar figure based on the number of hours reasonably expended on the litigation. In other words, you get paid for how much you work, which is still going to be a ridiculous amount here. It's the hourly rates ranging from $2,250 an hour to $550 an hour. Man, I should have become a lawyer. Those are reasonable. Hey, that much per hour, it's reasonable. Accordingly, the claim total lodestar of $27 million in change is presumptively reasonable. Hey, Judge, can I have a presumptively reasonable amount of money? I think that would be presumptively reasonable. I'll take that. Now, the reasons why it's so much is because this is the largest copyright class action settlement in history. So they did a lot of work to get that, so they deserve a lot of the money. The size of the $1.5 billion non-reversionary settlement gives class members a per-work award of about $3,000 less costs and fees. That's more than 4 times the statutory minimum for ordinary infringement and more than 15 times the statutory minimum for innocent infringement. And it's a hell of a lot when you consider this was judged to be fair use. It's infinity% greater than they should have gotten, which is nothing. You shouldn't have to pay anything if it's fair use. But they made a central library. That makes no sense. Like, what do you think they were going to do with that? Regardless of what you were thinking they were going to do with it, you don't get to do pre-crime. This isn't Minority Report. I'm sorry, that was ridiculous. All right, class counsel also secured non-monetary relief. See, there's things that aren't measured in dollars that they got a big benefit for authors too. The settlement requires Anthropic to destroy all of the original files of works torrented or downloaded from LibGen or Polimi and any copies that originate from the torrented copies, subject to certain legal preservation obligations. This destruction is a benefit for class members. How? Who benefits from that? No one benefits from that! Copyright is crazy. Copyright is insane. But you could say that sentence with a straight face. Oh, there's a file sitting on a drive. We remove that file sitting on the drive and you benefit from that. In light of the above factors, the court finds that a multiplier of 3.75 for a total fee award of $101,561,111 is reasonable. Oh man. Someone pay me a reasonable amount of money. Hey, tell you what, go to donate.pagosity.tv and pay me what you think is reasonable. Here's what a judge says is reasonable. Is that reasonable? What you gonna get me for that? I just want something reasonable. Give me something reasonable. And for expenses, the request for reimbursement is granted in the amount of $2,635,197.46. So another $2.6 million on top of that. So, having considered the above, the court finds that the proposed settlement is fair, free of collusion, and consistent with plaintiff's fiduciary obligations to the class. The motion for final approval is hereby granted. The court disallows the opt-out submitted after February 9th, with the exception of a couple, which are allowed based on their showings of excusable neglect. I think one of them was in the hospital and they lived in Mexico and only spoke Spanish, and the notice was only given in English, and even then they were only like 3 or 4 days late. So the judge is like, okay, that I understand. The rest of you, especially that one who tried to do it at the last minute, nah, you're done. Forget it. The court grants plaintiff's motion for attorney fees to class counsel in the amount of $101.5 million, nearly 6.8% of the settlement fund, consisting of $1.5 billion plus interest paid by Anthropic or accrued in the settlement fund, reimbursement of expenses totaling $2.6 million, and a cost reserve of $18.2 million in anticipated expenses, and service awards of $15,000 for each of the settlement class representatives, totaling $45,000. Man, I am definitely in the wrong line of work. I couldn't be a lawyer, though. I couldn't do this. I couldn't make all these arguments with a straight face. And I'm not corrupt enough to be a judge, so there you are. The above captioned action is dismissed in its entirety with prejudice. The clerk shall close the file in this matter. It is so ordered. Judge Araceli Martinez Olguin, United States District Judge. Well, it's not over though, because we're going to have all these things going to the special master, all these disputes between authors and publishers, and we may even see some appeals from this. Because a lot of these objections that were overruled here, some of them might go up to the Ninth Circuit and say, yeah, the judge ruled the wrong way on this. We need that overruled. We'll have to see what happens. I don't think there will be any appeals from Anthropic because he can't really appeal a settlement. That kind of defeats the purpose of a settlement. And the same thing with the plaintiff's counsel and the class counsel. But for us, that ties up this case in a bow. Thank you for coming on this almost 2-year-long journey with me, where we saw one of the best fair use rulings of our time. Hopefully it'll be applied to the rest. But of course, it's just the beginning of the rest of the AI cases, because there's dozens and dozens of others out there, more being filed all the time. So stick with me, I'll let you know the important ones. Comments for the Common God, shares for the Share Throne. Please hit like, subscribe, and the bell, and of course, donate.pagosity.tv to pay me something reasonable. And you can reasonably make a one-time payment, or I think it would be reasonable if you became a regular supporter and got all sorts of reasonable benefits, including getting these videos early and ad-free, live streams, AMAs. Check all of that out. Thank you so very much for watching. Until next time, stay strong and be free.